Before proceeding further, this court would clarify at this stage that the present petition is not an application seeking grant of bail, but release on ground of arrest of petitioner being illegal and in violation of principles laid down in the Honorable Supreme Court in the case of Pankaj Bansal versus Union of India. For those who don't understand English, whatever little Hindi I know this thing, I would be telling them this. ये कोर्ट अगला फैसला सुनाने से पहले इस बात को साफ करना चाहती है कि ये पिटिशन बेल के लिए नहीं है। ये पिटिशन ये साबित करने के लिए है कि जो पिटिशनर हैं उनकी अरेस्ट इलीगल थी और सुप्रीम कोर्ट के फैसले के कॉन्ट्रावेंशन में थी। The issue before this court is whether the arrest of the petitioner is illegal and arbitrary, and whether the arrest order dated so and so and the consequent remand order passed by the learned session court was in violation of the decision of the Honorable Apex Court.
Importance. Everything is important.
मैं सुन तो दो मुझे यार। बैठो बैठो तुम यार, कोई बोल रहा ना यार। मैं बैठ
माइक ऑफ रखिए प्लीज।
The second issue before this court was whether the petitioner is entitled to be released from custody in view of his arrest and remand order. The material which has been collected by ED reveals that Shri Arvind Kejriwal had conspired with other persons and was actively involved in the formulation of Delhi policy 2120 in the process of demanding as well as in generation use of proceeds of is also allegedly involved in the offence of money. Firstly, personal capacity was involved in formulation of the excise in demanding it. Secondly, in his capacity, the national convener as per MLA for use of proceeds of rupees 55 crores in the election campaign, for elections, print the material relied either as well as statement recorded on 8th of March 24 of one of the candidates of AAP in Goa elections 2022, which has been discussed in this judgment. Shri Singhvi, senior counsel for the petitioner, during the course of arguments has questioned the credibility of statement of the approver in the present case. It was one of his arguments that in their statements, which have been relied upon by the prosecution, these approvers have not implicated the petitioner herein initially, but only at the later stage in exchange of ensuring that they get bail and pardon, and thus the statements are unreliable. After hearing this argument, this court is of the opinion that in the present case, among the several statements which have been recorded by ED, the statements of Shri Raghav and Shri Sharat Reddy are the statements of approvers, which are being termed as unreliable by the petitioner. The statement of Shri Raghav was recorded by the competent officer of Directorate of Enforcement under Section 50, and on 26 July, it was recorded under Section 164 of CRPC by the concerned judge, whereas the statement of Sharat Reddy was recorded under Section 50 of PMLA on 25/4/23 and under 164 on 29/4/23. Thereafter, I have given a table in which I have told you I have tried to discuss as to what is the difference between Section 50 of PMLA and statement of approver recorded under Section 164 of CRPC. This court holds that the contents of para 84, which talks about the difference between Section 50 and 164 of CRPC, would lead to a conclusion that to doubt and cast aspersions regarding the manner of granting pardon or recording statements of approver amounts to casting aspersions on the judicial process. Since granting of pardon or recording of statement of approver is not the domain of investigating agency, it is a judicial process wherein a judicial officer follows the provisions of CRPC for recording the statement of an approver and also for granting or not granting pardon such approver. In a nutshell, to say it in Hindi, जब भी किसी अप्रूवर का बयान लिखा जाता है तो अप्रूवर का बयान ईडी नहीं लिखती, अप्रूवर का बयान कोर्ट के द्वारा लिखा जाता है, जो एक जुडिशियल मैजिस्ट्रेट लिखते हैं। जब आप ये कहते हैं कि उनका पार्डन ग्रांट करना या उनकी स्टेटमेंट लिखना गलत था, तो आप जज के ऊपर एस्पर्शंस कास्ट। In this context, it will also be important to note that an approver, who is an approver, is an individual who provides crucial evidence against co-accused in exchange for leniency or immunity from prosecution as per law. However, it is the court of law that evaluates the credibility and relevance of the evidence presented by the approver and determines whether to accept their testimony or not at the relevant stage of trial. Similarly, bail, which entails the release of an accused pending, is a judicial prerogative and not prerogative of ED. Without challenging the said process, to hold that the statement of approvers and pardon granted to them was at the behest of ED, in this case will be questioning the judicial process, which is governed by the law and not by any government or investigating agency. The law of approver, this is important. The law of approver is more than 100 years old. In the old code, it was section 337 and in the new 306. And it is not a 1-year-old law to suggest as if it was enacted to falsely implicate the present petitioner and co-accused persons in this case. The law has been in existence, even birth of many of us who are reading this judgment and one who's writing it. The law on approver, as well as the law on its evidentiary value, has been tested by the Privy Council and the Honorable Supreme Court in innumerable cases and has not been struck down to be unconstitutional till date by any court of law. The present case is neither the first one nor the last one wherein the approver statements have been recorded or have been relied upon by the prosecution. Quote, trials have taken place, trials are taking place, and have ended in conviction or acquittal in which approval statements have been recorded and relied upon by the prosecution. Further, the question of non-supply of the documents and earlier statements of the approvers, I have said that you will be entitled to the relied and unrelied documents as per law at the stage of 207. As an accused, you are entitled to that, yet that stage has not. In addition to questioning the value of an approver's statement, Shri Singhvi also questioned the credibility of statement of one of the witnesses, Shri M.S. Reddy, which has been recorded under Section 50 as well as 164 of CRPC, on the ground that his statement was recorded immediately prior to hearing of bail application of his son, Raghav. And recently, Shri M.S. Reddy has been given a ticket to contest the upcoming Lok Sabha elections from the alliance of ruling party. Similarly, Shri Singhvi also stated that the statement of the approver, Shri Sarath Reddy, is also not reliable since it has been discovered that he had paid an amount of 60 crores approximately to the ruling party at the center through electoral votes. In this court's opinion, who gives tickets for contesting elections to whom or who purchases electoral bonds, what purpose, is not the concern of this, as this court is required to apply the law and the evidence before it as it is and in the context in which it has been placed before this court. This court also wonders as to whether it can, while deciding the present petition, seeking declaration of arrest of petitioner as illegal, put fetters on a witness who is not an accused to contest elections and question his credibility. Whether M.S. Reddy or Sharath Reddy have given their statements out of their own free will, and the reason for not coming out with facts in their statements against a particular person at a particular time cannot be questioned by this court at this stage. However, the accused, as a matter of right, will be able to question it by way of cross-examination at the stage of trial. Shri Kejriwal will have a valuable right to cross-examine these witnesses as to why they have chosen to give a statement against him after initially giving statements in which he had not implicated him. The said person will have to answer it at that stage, and the evidentiary value of that statement will have to be adjudicated by the trial court at that stage. This court cannot step into the shoes of the trial court and conduct a mini trial in a writ jurisdiction. Whether the petitioner is entitled to any special privilege for the purpose of complying with summons under Section 50 of PMLA. Shri Singhvi has argued that even if the petitioner had not personally appeared before the investigating agency, pursuant to receipt of summons under Section 50 of PMLA, the respondent agency could have questioned him through video conferencing or by sending him a questionnaire or by visiting his residence to record his statement for the purpose of investigation in the present case. In this court's opinion, at the outset, this contention has to be rejected, since the investigating agency, under the Indian criminal jurisprudence, cannot be directed to conduct investigation in accordance with convenience or dictates of a person. The investigation has to take its own course, and in case the investigating agency would be directed to visit the house of every such person for the purpose of investigation of their cases, the very purpose of investigation would be lost and would end in chaos. In this regard, a reliance has been placed on Supreme Court's three four judgments of the Supreme Court, which say the same thing that this court is saying. Further, this court holds that this court would not lay down two different categories of laws, one for the common citizens and the other granting special privilege to be extended by investigating agency either to a chief minister or any person in power only on the basis of being in that public office, since the public office is enjoyed by that public figure due to the mandate by the public. In the recent case of Amanatullah Khan versus ED, this court had an occasion to also hold and reiterate investigation for classes and masses cannot be different, and beyond privileges we can the public figures are also beyond privileges, and their accountability has to be held to the public. The timing of the arrest. Shri Singhvi stated that the arrest of the petitioner is illegal on the ground of the malified intention and the arbitrariness reflected in the manner and the timing of arrest, and his arrest raises serious questions about the level playing field in the upcoming Lok Sabha elections 2024 for the reason of petitioner not being able to campaign for the elections. This court is of the opinion that the petitioner herein has been arrested in a money laundering case and has been presented before the special court, and the courts have to examine his arrest and remand in context of the law concerning arrest and remand, irrespective of the timing of the elections. In absence of any malified intention on part of Directorate of Enforcement, which would be apparent on record, accepting this argument would mean that in case the petitioner would have been arrested in October 23 itself, his arrest would not have been challenged on the ground of malifieds, since elections were not declared at that point of time. In case this argument is accepted, it would amount to accepting that in a case a person delays presenting himself before the investigating agency, he can take advantage of the same and later take a plea of malifieds, since the time when the investigating agency arrests him does not suit him either personally or professionally. Sri Kejriwal also must have been aware about the impending Lok Sabha election dates, which were likely to be declared in the month of March 24, which has been mentioned by him in his replies to students. He would have known when Lok Sabha elections will be declared. He would have be and he will be very busy than ever at that time. And then thereafter, observations that he was unable to uh, join the he was unable to join the investigation. This court is further of the opinion that to hold that the time was chosen by the investigating agency will be accepting an argument that the petitioner who had delayed the investigation to the point of his arrest and the courts had refused to grant him relief from arrest from joining investigation, it was ED which had decided the timing of his arrest. The contention of Shri Singhvi that the petitioner has been put in jail deliberately so that he is put at a disadvantage during an election process is reiteration of the argument of arrest being malified. Was there any reason or necessity to arrest the petitioner? One of the arguments raised by petitioner was there was no necessity to arrest the I'm so sorry. There was no necessity to arrest the person in this case. In this regard, this court has made a reference to the decision of Vijay Madan Lal Chaudhary and states and Pankaj Bansal and holds that the ED was in possession of enough material in enough material which had led them to arrest the present accused. Impact of non-joining of investigation by the petitioner on the trial of co-accused persons. delay caused by Shri Kejriwal was also impacting those who were in judicial custody, and there was a judgment of the Supreme Court to try those cases expeditiously. Was non-joining of investigation by Shri Kejriwal a contributory factor? It was only a contributory factor and not the only factor. Conclusion. The state is static. The governments are at the will of the people. While concluding, this court holds that judges are bound by law and not by politics. This court also holds that judgments are driven by legal principles and not political affiliations. The courts of law are one of the pillars of democracy. Judges, as custodians of justice, are bound by the law and not by political considerations. The independence of judiciary not only refers to judgments independent of hidden or apparent biases, but also independent of the effect of political affiliations of those who are appearing and are parties before them. The oath of a judge binds her to the Constitution through its words, which always resound in her ears and are etched in her mind. In this regard, this court notes that the judiciary is tasked with interpreting laws and adjudicating matters before it based on existing laws and precedents and not by political considerations of either party. In the realm of legal adjudication, courts are only and only tasked with interpreting and applying the law as it is, rather than going into the realm of politics. The judiciary operates within the framework of legal principles and constitutional mandates, focusing on upholding the rule of law and ensuring justice is administered impartially to both the parties. While politics may influence governance, it is not the purview of the courts to adjudicate political matters. Instead, the judiciary remains steadfast in its commitment to the principles of law and justice, independent of political consideration. When confronted with cases involving political figures, the judiciary relies on the Constitution, and that is the only paramount consideration before this court also wants to place on record the observation that the state is an entity and is not confined to a person. This court observes that political considerations and equations cannot be brought before a court of law as they are not relevant to the legal proceedings. In the case at hand, it is important to clarify that the matter before this court is not a conflict between the central government and the petitioner, Sri Kejriwal. Instead, it is a case between the petitioner, Sri Kejriwal, and the Director of Enforcement. In such legal proceedings, it is crucial for the court to maintain its focus solely on the legal merits of the case. Political factors or dynamics should not and have not influenced the court's deliberations or decision making process. An attempt to introduce political considerations into the proceedings would undermine the integrity of the legal process and would compromise the pursuit of justice. Therefore, it is essential for this court to remain vigilant in ensuring that the case is adjudicated based only on legal principles and not influenced by any extraneous factor. The issue before this court does not concern two political parties, but an investigating agency on one hand, and an alleged accused who happens to be chief minister on the other hand. The courts have been and are better left untouched by political influences or interferences and concentrate only and have the sole responsibility to apply the law as it is. The petitioner or the respondent may find the court to be excessively harsh or lenient in their cases. However, the court has to be dispassionate and only keep its concern with the application of law and decide the case before it accordingly. Courts are concerned with constitutional morality and not political morality. कोर्ट्स का कंसर्न संवैधानिक नैतिकता से है, राजनीतिक नैतिकता से नहीं है. And this is why this court wants to place this also on record, that as custodians of justice, this court is primarily only concerned with upholding constitutional morality, rather than getting into political morality of parties appearing before it, as the issue of political morality is not the concern of this court and cannot form, and this court will not form its judgment on the basis of that. When adjudicating legal disputes, this court has been duty-bound to interpret law and assess action of the investigating agency in alignment with constitutional and legal legal material which was before this court. To sum up, the files which were placed before this court and the material which was placed before this court by ED reveals that the petitioner herein was granted and all the mandate of the law which was laid down in the case of Pankaj Bansal was followed. The order passed by the concerned magistrate was not a two-line order but was a reasoned order. The material before the ED which was placed before this court included the statements of the Hawala dealers. They also included one of the statements of one of the own candidates of AAP, who was a candidate and who got elections in Goa in the year 2022. The names of that person and the names of the Hawala dealers, the surveyors, assembly assessors are not being disclosed in this judgment, though the file was handed over to this court, so that the case of the petitioner is also not the case of the petitioner is also not adversely impacted by disclosing those names. This court therefore holds that before this court, the ED was able to place enough material in the shape of Hawala dealers' statements, the statements of the approvers, the statements of their own candidate who refer to the fact that he was granted and he was given the money in cash for expenditure in Goa elections. And this court also has gone through the statements which complete the chain as far as the money was sent in cash for Goa elections. As far as Section 70 is concerned, this court also holds that not affect the case of the petitioner. In view of this discussion, this court holds that the arrest of the petitioner herein, Shri Kejriwal, was not in contravention of section concerned or the case of Pankaj Bansal. Consequent to that, his remand therefore cannot be termed as illegal, though it was not argued before this court as to whether the subsequent two remands were illegal or not. However, this court deems it appropriate to refer to them and state that even those two remands due to which Sri Kejriwal is at present in jail were also at behest of Sri Kejriwal himself, who stated that he could be sent to judicial custody, and his counsel on the next said that he could be sent to judicial custody and he had no objection to the same. In view thereof, the petition filed before this court stands dismissed.